There's a number buried in American copyright law that should keep every AI company's lawyers up at night. $150,000. That is the most a court can make you pay for copying one work, one time, on purpose. Now picture a company that trained its model on millions of them. And here's the knot we're going to untie today. The same year, one AI company paid authors $1.5 billion over this exact fight. A federal judge looked at what these models do with your words and called it, and this is a real quote, exceedingly transformative. $1 billion payout, and a judge saying it's legal. Park that. By the end, you'll see how both of those live in the same courtroom.
I'll take the wonky end of this. I'm Erica, and step 1 is just getting the phrase right because it's doing a lot of hiding.
Michael here. Think of it as a fire hose, not a filing cabinet. Books, art, code, news, your photos, all of it scraped off the open web at a scale no library has ever held.
This is Elena, and here's the part that breaks people's intuition. It doesn't get filed away as copies. It gets absorbed as patterns spread across billions of tiny numbers.
Which is exactly why this is a fight and not a rule book. The clause says $150,000 a work, but nobody kept a copy of the work. Last time we taught you to distrust what you see, the deep fake. On our way out, we promised we'd open this room, the one where your own words go. This is it. And the reason it's a brawl, the courts are writing the rules live, one case at a time. Elena, you flagged something before we rolled that I think half the audience is already shouting at the screen. Go ahead.
Yeah, fine. I'll say it out loud. Did they train on my work? And do I get anything for it? And the honest answer is the whole episode. Some people already got paid. Most never will.
8 of the biggest copyright cases in the country turn on that one question. 8, right now. Michael, forget the lawyers for 1 minute. When a model trains on my blog post physically, where do my actual words go?
This is layer 3 of the AI stack, by the way, the data. Everything this fight is about. Michael's the right person to walk it, but I'll frame it. The record's clear on the mechanism even when the law isn't.
It reads it, then it throws your blog post away, keeps the pattern, tosses the paper.
Right, and picture your writing going into a blender with a few billion other things. What comes out is a smoothie. Your strawberry is in there somewhere, but you cannot pour the strawberry back out. That's what a book becomes, smeared across billions of dials.
And it's reading at a scale that won't fit in your head. A single training run pulls in more text than a person could finish in 10,000 lifetimes, chewing through rooms that look like this one.
Here's the catch that makes lawyers crazy. There's no copy in there to point at.
Let me put the two things side by side, because this one distinction is the entire ballgame.
If it isn't a copy, and it isn't nothing, the honest word for what's left is
somebody's evidence.
Evidence, sure, residue that's worth fighting over, because one company just paid a fortune rather than let a judge define the word.
And you can't delete one book back out of it. It's baked into the whole thing. Ask any engineer.
Here's the failure mode nobody planned for. When this breaks, when a court someday says take that one book out of the model, there is no clean way to do it. You'd basically have to retrain the whole thing from scratch.
Mark that word, residue. I have scanned and filed every family receipt since 2009, the whole archive, so believe me, I want a paper trail. And here, there isn't one. A judge in Manhattan is weighing that exact problem right now, and that fortune Alina mentioned, I want to walk you through the math on it in about 60 seconds, real quick, because this next part matters to you. If any of this is helping, tap that like button, then hit subscribe and ring the bell so the next one finds you. Both are free and take about a second, but they tell the algorithm to show this to one more person who needs it.
Word for word, That is the accusation at the heart of the biggest fight there is. The New York Times says it fed its own articles back out of ChatGPT near verbatim, and then it sued.
That case, filed at the end of 2023, is still grinding through discovery today. No verdict yet. This is the paper that brought it, and it is the one everybody is watching.
That verbatim thing has a name in the lab. When a model hands back a paragraph it basically memorized, that's not learning. Call it a bleed. The training bled straight through.
It's rare, but it's real, and it's worst for stuff that shows up 1,000 times in the data. Your one tweet? Safe. A famous passage printed all over the internet? That can bleed.
And here's where it lands in court, and it is genuinely not one answer. Same year, different judges, opposite results. One lab, Anthropic, agreed to pay $1.5 billion. But read the fine print, because that money was not for the training. It was for pirated copies of books sitting in a
Library, yeah. But flip it. Another court went the opposite way. Thomson Reuters versus Ross. First court in America to reject the fair use defense outright for AI training. So the scoreboard is genuinely split.
and it's gone global. Getty sued Stability over in the UK. In November 2025, a judge there ruled the model's weights aren't even a copy of the images, so Getty walked away from the heart of its own case. Different country, same impossible question.
So here's the number I promised you a minute ago. Why would anyone hand over $1.5 billion? Elena, put the exposure up on the board.
Watch this. Start with the books in that pirated library, about 500,000 of them. Now take the ceiling a court can charge for one willful copy, $150,000 each. Multiply them out. 500,000 books times 150 grand a book. That is $75 billion of exposure. So when a company settles for $1.5 billion, roughly 3,000 a book, that isn't a loss. That's a fire sale, and everyone in that courtroom knew it.
$75 billion in exposure, $1.5 billion paid, and not 1 cent of it was about whether a machine is allowed to read. Erica, here's the whole fight in one question. Is training fair use, or is it theft? Give me the strongest version of each side. Steel man both.
Happily, and fair use isn't a vibe, it's a 4-part test written straight into US copyright law. 2 of those factors carry most of the weight here. Let me put both arguments up side by side, because honestly, both of them have real teeth. The transformative side first. The model is learning, not reprinting. New purpose, new output. Judge Alsop called it exceedingly transformative. That is his actual word.
The other side, market substitution. Remember Erica's smoothie? If that smoothie ends up sold at the strawberry stand, now you've got a problem. When the output competes with the thing it learned from, the 4th factor flips against you. This isn't only about words. Back in episode 6, we told you the image fight was coming. Well, it's here. Visual artists sued the image generators, Anderson versus Stability, and that case survived every motion to throw it out and is grinding through discovery toward a trial. Same 4 factors, different medium.
So which side is actually winning?
Good instinct, quick gut check, no cheating. Of the big AI training cases decided so far, how many have the companies flat out lost? Erica, first number in your head.
Lost outright? I'd have guessed 4, maybe 5.
1. Exactly 1 clean loss. Thomson Reuters versus Ross. And even that was the narrow, non-generative kind, and it's on appeal. Alsop and the Meta case both leaned the lab's way. The Times case isn't decided. Mostly it's settlements and split rulings.
It isn't settled. It's being settled. Live. Here's the one I keep snagging on, and I honestly don't have a clean answer. If the model never keeps a copy, what exactly did they steal?
The chance to license it. That's the theft, if there is one. Not a stolen file, a stolen market. You walked past the checkout line.
And honestly, that's where I draw my own line. A model that helps you write a rough draft? Strongly transformative, I'm fine with it. A model that spits out a near copy of a living illustrator's style on demand, competing for her exact commissions? That one's a lot harder to defend, and I won't pretend otherwise.
Everything so far has been about their data. The books, the art, the news. The next 10 minutes is about yours, and it is the one part of this you can actually control.
Okay, personal one. Everything you have typed into a chatbot this year. The vents, the rough drafts, the medical stuff you'd never say out loud. Where did it go?
Depends on the tier. On the free consumer apps on by default, your words help train the next model.
And you can turn it off, but only going forward. Nothing already trained comes back. This is exactly where I want an outside read. Amara Adeyemi is on the line with us. She knows this cold. Amara.
Glad to. Short version, yes. The free consumer tiers do train on your chats by default, but not the way most people picture it.
So when I type something, is a human sitting there reading it?
Mostly no. It flows into aggregate training data, not somebody's inbox. The real issue isn't a person reading it, it's that once it's baked into a finished model, you can't pull it back.
So deleting my chat history scrubs it from the model, right?
That is the trap, and it's the number one thing people get wrong. No. Deleting the chat clears your history from your account. It does not untrain a model that already learned from it. Two completely different things. So the rule of thumb is simple. If you never touch your settings, then your chats.
Keep feeding the machine until you flip the switch. Right.
Exactly right. And that one switch is the only lever a regular person actually holds here, so let's make sure everyone can find it.
Which is Michael's bleed problem all over again, except now it's your diary. Michael, show them the actual off switch.
I photograph my motorcycle in pieces before I take it apart, so trust me on doing steps in order. 4 taps on ChatGPT. Log in and open settings. Second tab, data controls. Find improve the model for everyone. Switch it off.
The key thing to hold on to, it is off going forward, nothing retroactive, and the business and API tiers were never in the training pool to begin with. One last tip before I get out of your hair. Most of these apps also have a temporary chat mode. Turn it on, and that conversation isn't saved or trained on at all. It's the incognito window for your AI. That is the short version, and I was glad to help.
So you can protect the next conversation, but everything you typed before today that's already out there, inside models people are using right this second, which is why the fight is quietly shifting from the past to the future. The real question now is who gets paid for the next training run.
That's where 2 futures are forming. Path 1, licensing. Labs cut checks. News companies, image libraries, music catalogs are already signing deals. The data becomes a market.
Path 2 is just the status quo. Scrape first, get sued later, settle if you have to. And when this breaks, it breaks on the small creators who can't afford to sue anybody.
So who actually gets paid when you say yes to a license, Erica? Follow the money for me.
Right now, the big rights holders. A New York Times, a giant catalog. The individual blogger, the mid-list author, the working illustrator, they are mostly outside the deals. So the market answer is real, but it's lumpy, and the record's clear on that. The signed deals prove the shape of it. Major newswires and big stock photo libraries have already licensed their archives for real money. But those checks landed institutions, not with the person who posted one photo to their blog back in 2012.
Which is why I'll push on the rosy version. For most creators, the honest read is that scraping just quietly wins and
that's the brochure version, though. Ask the Record, Ross lost outright. Getty, over in the UK back in November 2025, got told the weights aren't even a copy. It cuts both ways, it's genuinely unsettled.
Wait. Is there a version where a normal person gets paid?
Small levers, honestly. Collective licensing pools, opt-in registries, and the robots.txt file that tells the crawlers to stay out.
The clause says no, but only if the crawler chooses to listen, and plenty of them don't.
Here's the edge case that keeps me up. What about a model trained before any of these rulings existed? Is that grandfathered in, or is it retroactively illegal?
Nobody knows yet. That's literally what Discovery in the Times case is fighting over right now.
So sit with that. The biggest models running on Earth today are legally undefined. That's not a dodge. That's the actual state of the law.
Here's where I land, and it finally answers the puzzle from the very top. Remember the knot, $1.5 billion payout in the same breath as a judge calling it legal. Here's how those two fit together. The judge blessed the learning. The money was for the stealing, the pirated copies sitting in a library. Same case, two halves. So the line was never, can a machine read your work? It's how it got the work, and whether the output turns around and competes with you. Inside that line, it's fair use. Step over it, and it's infringement.
All of that is the past. The fight that hasn't happened yet is over the next model. The one trained on everything made after the courts finish arguing. On that one, you might actually get a vote.
So here is what you can actually do with all of this. You can't untrain the past, but you can shut off your own tap, tell the crawlers no, and watch which labs sign real deals instead of scraping in the dark. That's not nothing. That is leverage. "20 minutes, one line." This was never about whether a machine is allowed to read your work. It's about how it got your work and whether it turns around and competes with you.
Next time we unplug the courtroom and follow the power cord. Every one of these answers runs on electricity, way more than you'd guess, and somebody's paying that bill too.
The thing you can do tonight takes about 10 seconds. Open your AI settings, find data controls, turn off model training. It only protects what you type from here on, but from here on is yours to keep.
And the part I keep sitting with is who absorbs this. A studio with lawyers can survive a bad ruling. The person doing this alone, at night, after the day job, absorbs it with nothing underneath them. Whatever gets decided, that is who feels it first.
If this made a genuinely messy fight finally click, hit like and subscribe, because we're building this whole series into a way to actually understand AI, one clear piece at a time, no hype. So here's the question we could never put to bed. If a machine learns from your work the way a student does, should it still have to pay you? Tell us below. We read them. That's the data layer. I'm Caroline. Thanks for thinking it through with us, and we will see you in the next one. If the fee is hard to find, that is the fee to worry about.
I will say this for Caroline: no drift, no filler, no apologies. 9 out of 10. This is Professor Erica. Thanks for watching and signing off.